Legal Matters.
Kerry von Ludwig is my guest. She's a family law attorney and she joins me now on the line. Kerry, thank you so much for joining us this evening. Really appreciate your time. I imagine that the laws in South Africa want to be equitable and fair in the way that they are applied. But there seems to be a lingering perception that when it comes to issues of custody, I'll use that word, but I know that there's a better way of expressing this, in disputes between people whose relationship has suffered for one way or the other and that they are children, there's a perception that the law seems to favor moms than it does fathers in those relationships. How true is that? Kerry, good evening.
Outdated. Hello. Lovely to be here again. So nice to hear your voice.
Indeed. Thank you so much. Yeah.
Outdated perception. Lovely to have the opportunity to say that out loud on radio. Let's kill that perception. Let's sort it out once and for all to all of our listeners. It's dead. It's gone. It's outdated. It's old school. We're talking about current family courts. And if you find yourself in perhaps a children's court, in a magistrate's court that is a little bit behind the times, it is your obligation and your right to speak out. Whether you're a mother who wants the father to be involved or you're a father who wants to be involved or whatever you are, we're talking about parenting rights and responsibilities. So whichever parent you are who believes that you are acting in the best interests of your child. And there I do sound like an old school principal from the whenevers, the times before us. The best interest of your child, let me put it in bright lights out there. If you believe that that is what you are doing and you can genuinely say, this is not about me. I honestly can step back a little bit and look at what's best for my kid. Then you have the obligation, not only the right, but the responsibility to stand up and say, listen to me. Whoever you are, whether you're the mum or the dad.
Yeah. You spoke about courts sometimes that may still be hankering on and operating like they come from the dark ages in terms of these principles. How prevalent are those kinds of courts? I know that the laws are very progressive, the laws themselves. But is it possible? Is it possible?
Careful.
Yeah.
I must be so careful because I work and I sometimes as an acting judge preside in Gauteng, which is Johannesburg,
Yeah.
the Gauteng local division.
Yeah.
And I work in the courts around there. And and I like to say inclusive because family law is about us. It's inclusive. We are progressive. I haven't been in other jurisdictions. I don't know which ones are not progressive. I would like to believe that most of us are progressive. But from what I'm hearing from other people, there are some that are maybe not. And there are some that are stuck in maybe darky ages. But if they are, and I'm not going to point fingers or say because I don't have personal knowledge, we all have listeners coming in and going, I was in the court of blah, 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 and this happened to me. First thing we've got to be careful of is, did it happen to you because the court is not progressive, the court is not up to date with current law, or did it happen to you because you weren't focusing on what was best for your child? So I'm not going to say. I'm going to be on the fence on that one.
Yeah. And I suppose it's that opaque sort of space that those who claim and have perhaps even given some sort of evidence of the mistreatment, particularly fathers, who say that the preference that is given to moms, and I suppose that, as you say, comes from a bygone era that assumed that the most eligible nurturer in any relationship would be the mother, are going to say that we have evidence of that kind of old ways of doing things.
Look, let's be fair.
Yeah.
Sorry, am I cutting you short?
No, go ahead.
Let's be fair. And I mean, I'm a little bit old school. I mean, we know that I'm not young. We know that I'm 61. We know that I've been doing this for a long time.
Oh, you're a spring chicken, Kerry.
But I love you. But you and me aside, let's be realistic.
Yes.
The fact of the matter is, and I'm not entirely up to date on modern technology, but mums carry children. Mums are the ones who are pregnant. I have never had a child, and I'm the first to say to anybody, I don't understand what it means to be pregnant, to give birth, to have those first moments of a child in your arms, on your chest, when that newborn baby is placed on your chest. I don't understand that. But no matter how male you are, no matter how unparenty you are, no matter how whatever you are, the fact of the matter is it's an unequal contest because mums have that baby in their womb for 9 months. And it is an unfair advantage. That being said, there are many who pop it out and give birth and don't care. There are as many, probably 1 million more, who pop it out and give birth and feel those amazing feelings that I'm told they feel. It doesn't mean dads can't. It doesn't mean that other partners of other genders who are with their partner carrying a baby can't feel through the tummy, watch the scans, do all of those things. But there just is, we might want to be as woke can be. The fact of the matter is there is one person, whoever they may be, who has that baby in their womb for 9 months. And predominantly, that has to mean a little bit more in the weighing up of all the evidence. Once baby is born, I think we're on an even playing field, to coin that horrid old phrase, that baby can bond equally with whomever, granny, the carer, the whomever. But we can't deny biology at this stage of our evolution.
Do you think that the archaic principles that we've talked about are steeped in that notion that mom, because of the fact that for 9 months she is carrying baby for that time, has some level of, I don't know, a bigger right over the child because of that?
I don't think it's a bigger right. I think that if we accurately look at child law, it's a question of evidence, it's child-centric, and it is circumstance-specific. And whatever those particular parents or role players, because when we're talking about role players, you may have grannies, you may have siblings, you may have all kinds of other people who are clamoring for parental responsibilities and rights. But those people will step in and say, this is the role I played. I was the one who caught the baby. I was the one who cut the cord. I was the one who, when the biological birth giver couldn't anymore because of whatever reason, I did this. And it's evidence specific. I don't want to use the word evidence because it makes it sound so legalistic. So let's just call it, it's actuality, it's reality, it's life specific. If you come into a child's life 5 years down the line and go, hey, cool, I gave birth to this child, or I am the person whose sperm this is, or whatever, what relationship do you have? But if you are the person who was there at birth and was the first to hold the child and nourished that child, does it matter if it came out of your womb, or you are the sperm giver, or you are a grandparent, or who you are? It's who the child is bonded to and who has cared for and loved and formed those relationships with that child throughout the child's life. And we're not only talking about day one, we're talking throughout the child's life.
Yeah. My guest is Kerry von Ludwig, family law attorney, talking about, I suppose, the law and the issues of child custody when the relationships between us as parents go awry. And I'd love to take your calls. Do you perhaps feel that the law is against you as a father and that access to your children has been difficult because of some of the archaic ideas that might exist around who is the natural sort of nurturer of the child? What is clear is that the laws are progressive, that they are here to be applied as fairly and equally, but most importantly, for the child's sake. And Kerry, that's where I'd like to go into this conversation. It appears that everybody in that argument, whatever that argument is, will talk about, I carried the child for 9 months, or I cut the umbilical cord, or I was there when the child was coughing and both you parents weren't there, and so forth. But all of those arguments are about them, not the child. How do we get to a point where we acknowledge the role that those that are arguing that way have played, but still understand that ultimately whatever decisions need to be made need to be centered on the child's welfare and, of course, the child themselves?
Well, this is what I love about your perception, and this is why no matter how late you phone me or anybody wants me to chat about this, so what I love about this is the reality of it. And, this is where people have got to, there's no science to family law. There's no brilliance or genius to family law. It's practicality. And the hard thing is to separate yourself out. The concept written down on paper is the best interests of the child. We can say it 1,000 times, but we're all human. And if I think I'm a good person, and I think my morals and values and way of living and whatever is good, and let's face it, most of us do. Very few of us can step back and say, I'm not so great, and I don't have such great morals, and I've messed up and whatever. Most of us think that what we want for our kids is the best. So I'm going to forge forward and go, this is my subjective judgment, and it's right, and it's good. And you, as the other parent, have betrayed me, or don't share those values, or those views, or that way of living. Therefore, you are automatically wrong/bad. And that is where we, and I don't say they, we as parents, because if I were involved in one of these cases, I'd be the same. This is where we lack objectivity. Is, you may believe, I don't know, let's think of blue is the best color in the world, and daytime is the best time of day, and tea is the best thing to drink. I may believe night is the best time in the world, and red is a wonderful color to encourage a child, and a child should drink water. Who is objectively, not a court, is going to objectively say which one is better or worse? And if we look at it objectively, neither is better or worse. And I deliberately chose those stupid examples. Is this school or that school? This language or that language? This length of contact time, that length of contact time? What is actually better? What does better mean? And I think that is where people, including myself as an attorney for certain clients, get stuck. Is you see that something is good, it isn't bad, it isn't harmful, therefore you say, why not? But if you're given another set of facts, they are probably equally good, unharmful, why not-ish.
Sure.
And when you have a child that is not parented by parents together, when you're together, even when you're together, you have those conflicts. We live together, we love each other, we adore each other, but I want to go to bed at 6 o'clock, you want to go to bed at 7 o'clock. You want to watch motor racing, I want to watch horse jumping. That's life. But who says motor racing is worse than horse jumping, or horse jumping is worse than motor racing? Once we split and we live in two homes, and your home is centered on motor racing, my home is centered on horse jumping, then it becomes a value judgment, it becomes a problem, and it becomes a dispute. And that is where we as people are unable to say, we're not in the same home, so there are going to be some disagreements. Not all conflict is bad. Not all conflict is death-defying and to the detriment of a child. Should the child do piano or guitar? Well, who knows? Maybe there isn't enough money to do both. Should the child do Kumon maths or extra poetry? There isn't enough money to do both. No one is going to be able to say which is better and which is worse unless they have hindsight. So how do you resolve that? And when you're not in a relationship where you love each other, you've got a great family, and you can go, well, babe, let's do 2 maths lessons and 2 poetry lessons. You're in a relationship where you don't like each other anymore. You're in conflict. You want to be right. You believe that maths is better than poetry or poetry is better than maths. You believe the other person is only imposing their will because they are self-centered, not because they care for the child. Then what do you do? What do you do?
Oh,
and
double one.
I can do no more than pose that as a question because there ain't no answer.
Oh, 1-1-883-0702 is the number to dial. We're talking about the law and how it, I suppose, deals with issues that are, require the wisdom of Solomon, or the wisdom of Job, yeah, and the patience of Job. I'm sorry. In dealing with issues where parents have fallen out of favor with each other. There are children born to the couple, and there's a sense sometimes from men that the courts, the law, is often on the side of the mother, and in many ways the law, the context sometimes is weaponized against the father who may want to have contact and want to be in the life of the child, but maybe it is used to try and extort money out of the man is sometimes what we are told. If that is your perception, give us a call and tell us why you believe that is the case. What do you make of the fact that on paper the law is progressive and it wants to be equitably applied to some of the various contexts? But then, of course, we have our courts, we have our legal system. I imagine, Kerry, that's where we then lean on the wisdom and the training of the legal practitioners, from the magistrates to the lawyers on all sides.
You know, we do. In an ideal world, the children's courts particularly are designed for the public. They're not necessarily designed for legal practitioners to represent the public. Again, we have the situation that legal training kind of allows you to step back and be objective as opposed to the subjective. And to look at it the way I've tried to explain it now and say to a client, are you actually thinking outside of yourself? Are you thinking of what is best for this child? Or are you thinking how much you hated that person, how they betrayed you, how because they can lie about, I don't know, money or having an affair or crashing the car, clearly they must be a horrible parent. Being a bad spouse, and bad is such, again, another subjective word.
Yeah.
But being a disappointing spouse or relationship partner or co-parent does not necessarily mean you want the worst for your kid. Very few parents will put their child in jeopardy just to spite the other parent. It's like that story, I'm not terribly biblical or religious, but about that story where someone in the Bible said, chop the child in half, and the parent who loved it the most said, don't do that.
Yep.
It's kind of that situation.
Yeah.
And one wants to be able to say to a parent, hang on a minute, is this about putting one over the other parent? Whether it's trying to extort a bit more money, and is it extortion of more money, or is it saying, listen, this child really needs A, B, and C. And if you want to take the child out for the weekend and jowl with the child, perhaps you should rather think whether the child's got enough, whether it's got soccer boots, or it's got ballet shoes, or I'm able to feed it properly before you take it out and play paddle with it, or go on the jowl with the child. It's very hard, and I fully accept that I, as a human person, may not be able to do it myself. So it's hard to impose on people to say, step back and look at, am I really being about, this is not about you and me.
Yeah.
This is about the child. And sometimes it's not possible. If you, for example, belong to a certain religious or cultural group, you've committed yourself to that way of life because you believe in it. You believe in it. So you obviously genuinely believe that that thing, whatever it may be, is best for your child. Maybe you were even, like, let's take a sport. You were a tennis player, and you honestly see all the brilliant things that tennis did for you as a youngster, and you want it for your child. But the co-parent believes that tennis is a flighty, silly, elitist sport, and the child would do better learning extra science.
Yeah.
Because maybe they did really well by doing science as a subject.
It's all
and getting
very
a great
subjective,
career.
yeah.
It's so subjective. And there is no answer. It's about balance, and it's about trying to reclaim that kind of when we conceived this child, most people, even if it was an accident or a mistake or a whatever, once we realized we were going to have this child and keep it, we wanted the best for this child. Are we consistent with that now? And even if your best and my best are different, is there maybe like a third best that's not yours and not mine, that someone else could advise us on, that the court... And I find myself, Aubrey, doing silly stuff, like saying to a parent, you know, do you really need to, I don't know, fight about this piano lesson and that speech lesson?
Yeah.
Why don't you not send the child to either? You both tell the child that you absolutely love that child, and would the child like to choose a treat for him or herself that comes to the cost of the speech lesson or the piano lesson? And the child chooses maybe a program on their iPad that they've always wanted. Hopefully it's not like a murderous game that they're all going to go around killing each other, because then you both have to say no anyway. But you know what I'm saying? Or
No,
they
absolutely.
We'd really like to go somewhere with our friends to have a picnic.
Yeah.
You know, listen to what the kid wants.
Sure. I mean, and I suppose that's really the crux of the matter, that a decision sometimes needs to be made because everybody has dug in their heels as to their subjective understanding of what's right for the child, when often it's what's right for me, and usually I'm punishing the other for unmet expectations by withholding or fighting for my version of what's best for the child. I'm interested. I want to take some calls now because we've got a lot of calls. But I'm interested to hear from you at some point as to what then are the guidelines for the practitioner, for the judge, for the magistrate, as to how to...
Can I quickly answer that before we take the calls? Because it might play out on the calls.
Yeah.
And I can't speak for everybody. I've had the exceptional privilege for the last couple of years of being an acting judge in the High Court, only in the family court. And the guidelines there, you find that when you get to that level of seniority and experience, that you're almost like an elder in the community. Mm-hmm. You have a sense of... You're allowed to look, and you're able to look at both arguments. You take them away with you, you consider them, you weigh them up, and you're then able to balance them. And what I take away from that is often if prospective litigants could go to friends, family members, someone they respect, whether it's a religious leader, a community leader, a person in their chosen activity, sport, life, wherever, family, and they go and say, listen, this person is thinking A, this person is thinking Z. Can you bring a degree of parity to this? Maybe just an older, unsubjectively involved person can look. A silly thing, a very silly thing. I had a divorce matter today where the one party was saying, I want to take both lamps in the spare room and both lamps in the main bedroom. The other party said, I would like one of the lamps in the spare room and one of the lamps in the main bedroom.
Yes.
I'm like, guys, you're being silly. Why doesn't one of you take the lamps in the spare room, 2 of, and the other one takes the lamps in the main bedroom, 2 of? So you are not breaking up either set of lamps, but you both get 2 lamps. Get my point? I wasn't involved in anything, but I looked at it objectively and went, silly. And that is, it can be a friend, it can be someone, but someone needs to bring a measure of, hang on guys, are you outside your heads? Because most of us as human beings can't get outside our heads when it comes to stuff that matters to us. And let's face it, our kids matter to us more than anything else. And as judges, all we are doing is we're getting outside your head as the applicant, outside your head as the respondent, looking at it with an overview, matching it up to the law, obviously, and then saying, is this not an equitable situation that serves the child? Generally speaking, not always. It's a compromise.
Let's talk to Anonymous in Pretoria. Good evening to you, Anonymous.
Yes, good day, Aubrey. How are you?
I'm very good, thanks, man. Go ahead. What's your question for Kerry?
Actually, it's not a question, and I just need some advice, the way out here.
Yeah.
I've got a lady with a child coming from a neighboring country. I won't mention the country.
Yeah.
That lady doesn't have proper documents for being in this country. The child was born at Femina Hospital in Pretoria. So now, as we are speaking to the lawyer, I need some advice, because now the child was born in 2022. Now he's 2 years, 6 months. He's not yet even registered at Home Affairs, because a mom says no, he wants his details to appear in the birth certificate. Then I said, how? Because now they will question you, you are not having documents, proper documents here. How your name is going to appear? Now I'm just want to find out now from the lawyer there that you're talking to, that what can I do now? Because the child must go to the creche. They'll ask for the birth certificate. Nothing.
What is your relationship to the child and to the mother?
No, I'm the father of the child.
Let me ask the caller, if I may.
Sure,
caller, are you on good terms with mom? Are you fighting with mom, or you and mom okay?
No, we are not in good terms.
You see, that's a problem, because really mum is the one who needs to register the child. She can register the child.
Hold on, Anonymous. Listen.
She can register the child in South Africa because the child was born here. But if she doesn't want to, I'm not sure if you have the right to go and register the child if you are not married to the mum. And
no.
That is where you...
The problem is...
Anonymous, listen to what Kerry is saying, and then I'll let you come in, right? Just hold on.
Okay.
So you were saying, Kerry?
That is where Anonymous does have a problem, because it is the mum who needs to register the child. If the dad is not married to the mum, I'm not sure that he has the right to go and obtain a birth certificate. It's the mum who needs to do so. And if dad is not going to be on the birth certificate, or the child is going to remain unregistered, which is a big problem, because the child shouldn't remain unregistered, because he or she is going to then be an undocumented child. Dad is not really going to have much of... A child doesn't need to be registered to go to creche. Child doesn't need to be registered. Maybe the creche will ask for those documents. Dad probably needs to go to his local children's court and bring some sort of an application for his parental responsibilities and rights to be recorded in respect of this child. And that will bring mom to the table to explain why the child is not registered, whether she believes the dad has any rights or not, and dad can then go from there. But dad, I think you must go to your local magistrate's court, ask for the children's court, and ask them to bring an application against the mum for your parental responsibilities and rights to be documented.
Anonymous?
No.
Yep.
Yes, Aubrey. The question was, her mom doesn't have proper documents. It's
that's irrelevant. That's irrelevant. You are still the dad, so you can still go to the children's court. Right?
I can go to the children's court.
Yes, because you're the father of the child, right? So you can go to the children's court and then ask for the application that Kerry is asking, is telling you.
Yeah, because I even went to
documents that you must take to the mum, and the mum must come to the children's court and tell her story. But it's not for you to tell the mom's story. It is the mom to explain her story. And if she says, well, I'm not documented, so you can't have rights, the children's court will explain to her that it doesn't matter if she's not documented. There is still a child and that child is entitled to involvement with its daddy.
Yeah.
Anonymous in Pretoria, thanks very much for your call. Much appreciated. Figula says, good evening, Aubrey and your guest. Can the attorney explain to many of families who are not allowed to see and support the child because they want intlaulo first? Also, the intlaulo is above 50,000 rands. Another thing is they don't want to give the father opportunity because of grant. After 18 years, they chase the child cause they are done with the grant. Okay, so a couple of things here, Kerry. This is the concept of intlaulo, meaning the payment of damages. I'm sure you're afraid with that. It says Figile that sometimes I'm not allowed, or the father's family or the father is not allowed to have access to the child because intlaulo or damages haven't been paid. And sometimes what happens is that they don't want to give father the opportunity to have access to the child because of the grant. And after the child is 18 and is no longer eligible to get the child or children's grant, then they will allow the father to get involved because they would have abused the grant. How do we respond to that?
If daddy is interested in the child, he's not going to wait 18 years. If daddy really wants to be involved with the child, he'll go as soon as possible. And the fight about Nklaulu, this is a very difficult thing to deal with, and it's a very hard thing to say because people can interpret it as disrespectful to customary law, disrespectful to custom. But the fact of the matter is we look at our civil law as per the statute books.
Yeah.
Whether it is right, whether it is wrong, whether it is progressive enough or not, is not for me to say.
Yeah.
I'm not here to make a value judgment. I'm not here to make a political or cultural judgment. I am here to interpret the law as it stands. And our law says that if a dad fulfills certain requirements in terms of Section 121 of the Children's Act, he has responsibilities and rights to his child. And the payment of damages is not one of those requirements. So again, dad can go to children's court and he can say, I am the dad, or to high court with legal aid, or if he can afford it, an attorney, or through pro bono or anything, and say, I am the dad. I want to exercise my responsibilities and my rights, and the mother is blocking me. The way she is blocking me is not legal. Saying that I didn't pay my damages, it's irrelevant. That is a thing to be dealt with through families and elders and custom and tradition. It is not the civil law. It does not block him. But a dad who sits around and says, oh, well, I'm a little bit scared and I only believe in traditional and customary law and I'm not going to invoke the laws of the country and I'm going to hang around, he's going to lose. You have to be proactive and, what is the word? I don't want to say irresponsible because it sounds so judgmental, but you have to be proactive and you have to look at the applicable current laws of the country.
Is that part of,
or don't they?
Is that part, my apologies, Kerry, is that part of what the courts will look at in making a decision as to the proactivity of the dad if he wants access to the child under these circumstances? Would that be part of what would influence the decision of the courts, the level of proactivity?
Absolutely. Section 21 of the Children's Act says that you either automatically acquire parental responsibilities and rights because you lived with the mother of the child at the time the child was born, in which case you are automatically a holder of parental responsibilities and rights, or you automatically acquire parental responsibilities and rights if you consent to being identified as the father of the child, and we don't have any evidence as to what that actually means. But, are you the dad or aren't you? And if you contribute or attempt reasonably to contribute to the maintenance and the upbringing of the child. So if you sit back forever and do nothing, and you didn't live with the mum, then you haven't reasonably contributed to the maintenance or the upbringing. But if you jump in and say, hold on, I'm trying to pay for this kid, And I'm trying to see this kid, and I'd love to see this kid. And my mum and dad are standing on the doorstep waiting, and I'd like to open an investment account, and I'd like to buy some nappies, and I'd like to pay some damages, but I can't pay 50,000 Rand. I'd like to pay 500 Rand, or whatever it may be. Then you are trying. And the courts are going to say, absolutely, maybe you do acquire your parental responsibilities and rights in terms of Section 21. And then you are in the door.
Yeah. Here's a question. This person says, good evening. What is the legal age for paying maintenance until? All right. So what is the limit of the age of the child who must receive paying or must receive maintenance from father or mother? Or does the parent paying it have to pay until child finish school, or is it 18? And that's from Devish. Devish is asking, what is the legal age of paying maintenance up to, I suppose?
Sir Aubrey and Mr. Devish, I'm going to spoil your show. The legal age of paying maintenance is up until the child becomes self-supporting. So your age of majority is 18.
Yes.
Generally, the claim belongs to the primary residence parent of the child. In other words, assume the child lives with mum, which is our most common but not always scenario.
Yeah.
Dad will pay mum maintenance for child till child becomes 18. Once child becomes 18, child is legally an adult. But not all children are self-supporting at 18. Many are still in school. Many are still in tertiary. Child can't support self. Does child have claim for maintenance until self-supporting? Absolutely. And it's a little bit of a complicated legal scenario as to whether mum still has the claim for maintenance or child has the claim. The sort of overriding principle is if child still lives with mum, you've got a child who's still at school, 18, 18 and a half, 19, maybe even 20, living with mum. Still mum makes breakfast, irons clothes, sends child off to school, whatever. Mum has the claim. Child is kind of living on his or her own, hanging around, going to school or going to college or writing through correspondence or doing their best. Child still has claim. The claim exists. Whether the child or the primary residence parent enforces the claim until the child is self-supporting.
Kerry von Ludwig, thank you very much, ma'am, for joining us this evening. We've run out of time, but it's been a deeply informative conversation, and thank you so much for joining us. How do people get in touch with you if they want to have more discussions or consult with you?
It's always my hugest pleasure, and I just want to thank you for inviting me because it's so stimulating, and you're such a fabulous host.
Thank you.
Try not to get in touch with me because I'm so overwhelmed I may disappoint you. But my email is Kerry, Ceri, at familylegal.coza. Please try not to abuse that. If you have a legitimate query or you want to be a client, you may find me there. But please remember, I'm a sole practitioner. I will give as much as I can, but I can't help the entire world. Kerry at Family Legal. Otherwise, keep listening to Aubrey. He'll always have something amazing to help you.
Kerry von Ludwig, thank you so much.